Welcome to this free immigration help channel. Today is June 1st, 2023, and we are getting into the volume 105 of me answering your immigration related questions. As you can see, I have all your comments pulled up in front of me. As always, before starting, I'm going to mention I am not an immigration attorney. This is not a legal advice. All the information provided in these videos on this channel are directly from official government sources like USCIS and of course the Department of State with their visa bulletin. So let's start with the very first comment from the Snooty Fox. Snooty Fox says, totally ridiculous that they still have the VAX requirement for AOS, adjustment of status, that is. Stuck waiting until they drop it. You can go across the border and they send you on your way. But if you want to follow the legal way, you are forced to have their shot. No thanks. Snooty, thank you for posting this comment. I can definitely 100% relate to this one. I do have a few petitions that I am waiting on, and I am honestly kind of wishing right now to take them, let them take a little longer before they get approved, before they get to the point where the interview is scheduled, where the beneficiary has to go and get their medical examination, because yes, I don't want that them to get the vaccination. It's ridiculous. You're 100% correct. And it is weird that it is still required, because we know that as of recently, I think it was May 11 or May 12, they dropped the requirement for the vaccination for international travelers. So literally anybody can come in now without any kind of proof of vaccination or anything like this. But for whatever reason, most of the people who are applying for adjustment of status have already been here in the United States of America, because you have to keep in mind that's the asylees, refugees, and employment based, whatever it is, and of course the family, the whole division of the family reunification, all these cases, they still do require to get the vaccination. It is ridiculous, and hopefully it will be dropped soon. As soon as it is, I will make a video and update everyone and congratulate everyone on dropping this ridiculous stuff. But as of for now, as you are yourself dealing with it, make sure to make your opinion known. Besides the comments on this channel and other channels, make sure to actually reach out to your local elected officials, state officials, senators, congressmen, whoever, and let them know that this is stupid and it needs to be removed, this requirement. But thank you very much for commenting. I'm going to post the response here, and we're going to move on to the next one from Nadine Parkinson. Nadine says, I'm living in Florida. I'm 37 years old. I'm out of status. So out of status, I'm assuming that's already not so good. My mother is the one who will be petitioning for me. If I put in my I-130 now, will the law that they are implementing now, how effective would it be doing so? Do you think I should put the I-130 in? Nadine, so because you're already out of status, that already creates the problems with your situation. Most likely you will have to be dealing with the inadmissibility waivers. So in this situation, I would highly recommend you reach out to multiple immigration attorneys. Just Google immigration attorney in my area. Make a list of the attorneys that, based on the reviews, give them a call. All of them. Make a list of, like, let's say 10, 15, 20 attorneys, right? And call all of them. The attorney that will be willing to speak with you on the phone directly, not through secretary, not through, you schedule a consultation and then we will talk. The attorneys that are trying to get the money out of you before you even commit to working with that attorney, get them off the list. Leave the ones on the list that offer free consultation, that are willing to talk to you over the phone without any problems, answer all your questions, and are willing to actually meet with you without any clauses saying that, you pay the fee first, or you sign the contract first, and then we will talk, and then we will see. Leave those attorneys on the list. Go to all of the consultations. You'll probably be left with 5, maybe even 3 attorneys on that list. Go to those attorneys, talk to them personally, ask them the questions, see what they say. Honestly, with just the first one that you're going to talk to, you will know whether it is the attorney that you want to work with or not. But I would definitely recommend reaching out to an attorney. Why? Because most likely, since you are already out of status, you most likely will be dealing with an inadmissibility waiver, whether your case is processed here in the United States or if you'll have to go through the embassy outside of the United States. You will have to deal with this because there will be a question somewhere along the way like, okay, Nadine, why have you been out of status? That's not very good. But as for I-130, as I think I already responded to your comment in the previous video, don't wait. Do not wait. The sooner you start it, the better it is, because these processes, they take forever. They take very, very long time. The backlog is a very serious issue. There's a very long time to wait because of the backlog. So the sooner you start this I-130, the better it is. All right, moving further to another question comment from Nadine. My under 21 son priority date, October 2020, and he is a documentary qualified from January 5, 2023. When will NVC schedule an interview for him? Do you think this interview will be in next interview schedule coming up? Okay, Nadine, so I'm struggling a little bit understanding your situation, because in one comment you say that you are out of status, and then on another comment you say that there's a petition for your under 21 son. You can't really have both. So if you're petitioning for your under 21 son, you are either a US citizen or you're a permanent resident. If you're a permanent resident, then obviously you have a status of permanent resident, and then your whole I-130 is, I'm not sure what this question is about. Unless somebody else petitioned for your son, I'm thinking somebody else petitioned for your son, and he is in, I'm not sure which category he is in. Let me know the category. Please clarify the situation, because it's completely confusing. The two comments that you posted, they contradict each other. It doesn't make any sense. You can't petition for your son if you are out of status. And you really, if you do have status, whether permanent resident, obviously, or US citizen, then obviously you don't need anyone to petition for you. So please clarify that, and I will try to better address your questions and your concerns. All right, moving further to Sergut. Sergut, thank you for another comment. Sergut, thank you for being publicly subscribed too. Sergut says, hello brother, how are you? I called and tried to check the May 2023 visa bulletin, and when he talks about all the countries of the world and reaches Africa, he says except Egypt. 10,000. Brother, what does that mean? Please check it. I wish you a good day. Sergut, thank you. So if you can clarify this as well, I would really need the clarification. Who says it? Is it somebody over the phone? Who told you, and who you called? Did you call the US Embassy? Did you call the NVC? I'm thinking it's either NVC or US Embassy, probably US Embassy. And also clarify his response, because I'm not sure what you are referring to when you say except Egypt 10,000. Doesn't sound clear. Alrighty, moving further to Diana S.O. Sir, my priority date is February 16, 2016, F1 category. Do you have early update? Okay, let's take a look. So F1, I'm going to assume this is all chargeability area. So F1, we're going to look at the visa bulletin. We're going to scroll down to the graph A to see the full scope of how long the backlog that you have to be dealing with until the immigrant visa is available. So if we look at the F1 first preference category, right now it is showing December 2014. December 2014, and Diana has the priority date in February 2016. So that is roughly a little bit over a year, like a year and 2 months. So Diana, you're looking at a year and 2 months roughly, according to the visa bulletin as of right now. But again, it's a rough estimate, because in a year, more backlog can accumulate, or maybe, hopefully, that would be nice, things might speed up. We all hope that they speed up, but most of the times the backlog keeps accumulating. That's why we have it in the first place. So don't be surprised if you're waiting a little bit longer. But as of right now, roughly about a year and 2 months. Okay, moving further to Orville Gordon. The embassy requested the police report for a while now, and the petitioner didn't see it in her email. Can it slow up the process even more? Category F1. Yes, Orville, it could definitely slow down. So the embassy have been requesting the police report. Now the question is, has the interview already took place, right? So if you receive the email, and in the email where they schedule the interview with the U.S. Embassy, they say, hey, we need the police report during the interview. You had to provide that police report to the NVC, so you should have the same police report for the embassy. In that case, if you just saw it and the interview didn't take place yet, no big deal. You'll just go to the interview, bring that police report, the same police report that was shown to the NVC, show it to the US Embassy. Now, if you went for an interview and you didn't have the police report and they said, okay, we do need the police report, bring it, and then they reschedule the interview. Obviously, yes, it does take longer time now because you have to wait for a new interview date. So for everyone who's watching these videos, make sure to read that email very, very carefully that you receive when your interview is scheduled, because they let you know which documents you need to bring, and some of these documents are different from what is required to become documentarily qualified. So make sure to read it very carefully and make sure to provide everything they are requesting during the interview. All right, let's move on to the next one from Masood Han. Hello, brother. Thanks for your hard work. You're very welcome, Masood. Thank you for watching. My new question is, last time I asked you, you replied very well. Sir, my documentarily qualification date is 29 September 2022, IR5. Still waiting for interview from Islamabad, Pakistan Embassy. Question is, I already have 5 years multiple visit visa. If I come to US, do you think my case can be transferred in US if I get any attorney? What you advise? Regards. Masood, excellent question. Thank you for asking. So, because you are already documentarily qualified, honestly, I would recommend, my personal recommendation is just stick with where the interview is going to be scheduled, because it's been since, so it's September 2022, right? It's been now, so September, okay, October, November, December, and right now we're in month 6. So it's been roughly like 9 months after you were documentarily qualified. So your interview should be literally anywhere around the corner. Your case is already in the US Embassy in Islamabad, all right? They're just waiting for the available appointment window and they will schedule your interview. So you can definitely ask for processing in the United States of America, but I wouldn't recommend do that because you're risking that you might delay it. Honestly, I would just wait and get your immigrant visa in Islamabad. Now, as regarding to the multiple entry visa, if you want to travel as of right now, before you're waiting for that immigration visa interview, if you want to travel back and forth, that's not a problem at all. And honestly, if you do decide to come here and have the case process here, obviously it's up to you. If you want to do that, you can. You really don't need an attorney either. You can just request it from NVC and have it processed here in one of the field offices. But again, you are risking some delay, unnecessary delay, because you've been already waiting for 9 months for your interview. So it literally should be somewhere around the corner. I would just wait for it, get it over with, and be done with it. But if you want to travel back and forth, it's not going to be a problem at all, because obviously your multiple entry visa is still valid. All right, moving further to Sandeep Kapila. Sandeep says, thank you, sir. Appreciate. You're very welcome, Sandeep. Hopefully you found my answer helpful. Moving further to Patience Sula. Hopefully I'm pronouncing the name correctly. Sorry if not. F22 is, where is that on visa bulletin? Okay, great question. So those visa categories like F11, F21, F22, so they are subcategories of the main family preference category, right? So we have F1, and then within F1 we have F11, which we read F11, and then F12, which is a derivative beneficiary. Same thing with F2. So if you're looking for F22, if you look at the F2, either F2A or F2B, that's going to be one of your categories. So great question. Thanks for asking. Looks like there's another question. Let me put the answer to this one, and we're going to move on to the next question from Patient Sula. Hello, my case now changed to the processing countdown to your case is taking longer than expected. It's been 6 months now. I-130 U.S. citizen filing for wife. How much more time would you guess to get a decision? Okay, patience. Great question. So, since it's already taking longer than expected, I would recommend submitting a case inquiry with USCIS. You probably know how it is done, but I will show for everyone. Everyone, whoever's watching this video, if it's going to be helpful, I'm going to show it. Might as well use the opportunity to demonstrate some navigation on USCIS, which is the official government website for U.S. Citizenship and Immigration Services. We're going to go to Tools. We're going to go to Case Status Online. And then we're going to scroll all the way down. And you will see Submit a Case Inquiry. So we're going to click on this, Visit Page. And here you will select the very first one, Case Outside Normal Processing Time. And that will give you the form, the online form itself, where you'll enter your receipt number. Form type obviously is going to be I-130. Petitioner information, date of birth, alien registration number if you have it, you might have it already. Mailing address, and then the last action taken on the case. So that would be, for example, case received, right? I-130, case was received. That's it. The email address, and then filed by obviously you, petitioner, yourself, and then submit it. That's not gonna do quite a lot. Most of the times they respond very boilerplate response. They just say, oh yeah, we're still processing your case, blah blah blah, whatever. But what it gives you leverage in case of the case is it's starting to become ridiculous. All right, it's becoming, it's 2 months, 3 months, 6 months past the normal processing time, and you're still not getting a response. And you need to use other avenues. You need to submit complaint. You need to submit inquiry, going above USCIS and requesting help from government officials. Then you will be able to say, yes, I have tried to resolve this directly with USCIS by submitting the case inquiry. Here is when I submitted it. Here is their boilerplate response. As you can see, they didn't tell me, they didn't answer my question. I'm reaching out to you now for help. So that's really the only thing why you would want to do that. Keep in mind though that most of the times, even when you check the processing times, and I'll show you, if we select I-130, let's say whatever, doesn't really matter, whichever category and whichever service center, you will see that it's only 80% of cases. So that means that there's still 20% of cases that are completed faster, and then there's some percentage of cases that take slower than the 80% of cases. But still, if it's a couple months, not a big deal. But if it's more than 10%, let's say for example, if the average is, let's say, 26.5 months. If it's taking now longer than 3 months, then yeah, definitely it's not good. If it's within like a couple weeks and month, give it a little bit more time. But if it's 10% of 26.5 would be 2.6 roughly month, 2.5 months. So if it's above that, then you need to start reaching out to USCIS and seeing what's going on. Alrighty, let me put the response here, and we're gonna move on to the next question from Mr. Vo. Mr. Vo says, let's see. Hello there, I am doing form I-130 petition for parents plus adjustment of status. Alright, great, so it means the parents are already here. My wife recently got her citizenship and I doing the I-130 online. I got the official statement page. What do I submit? Is it her parents' birth and marriage papers? There are tables like religious records, school records, census records, written statements, DNA test results. Okay, Mr. Wo, so that's a great question. So if you're filing it online, when it comes to parents, right? If you're filing for parents, really all you need to provide is just to establish their relationship, the parental relationship. So you're providing, if it's based on you're the petitioner. For your parents, you're providing your birth certificate, you're providing your parents' birth certificate, obviously you're providing the marriage certificate in both applications. So for your dad, marriage certificate, same marriage certificate for your mom, obviously birth certificate for your dad, birth certificate for your mom. I'm pretty sure you do need to provide the passport that they have, the international passport, that stuff. And then as for you, in order to establish the relationship to your parents, obviously your birth certificate, because in your birth certificate it will say that this is really my dad and this is really my mom, which most likely you will have to do a certified translation. As for other stuff, school records, census records, you really don't need to worry about those. Those are supplemental documents that a lot of times you don't even need to submit, especially in cases like when you petition for your parents. But great question. Thanks for asking. Good luck with your application. If you have any more questions along the way, don't hesitate to come back here on this channel and ask them. Just make sure, if you guys, and it goes for everyone, if you're asking questions on this channel, if you have any follow-up questions after my response, make sure to not post your response under my comment, because then I don't see the notification for this. Submit it as a separate comment in any of the videos and your comment will come up on this wall right here in front of me. Okay, moving further to Lekix Winden 157. Hi, F2B priority date is June 30, 2015. Documentarily qualified November 2021. All chargeability area. Can you estimate interview schedule time? Please, your advice. Thanks. Alrighty, let's take a look. So F2B priority date is June 2015. We already know that it's documentarily qualified, so we're going to be looking at the graph. Let me close all this stuff that I have here. Graph A. So F2B. So right now it is showing all chargeability area F2B is showing September 2015. So right here we have June 2015. Wow, okay, so it's earlier. It's earlier than what it is showing. So judging by the visa bulletin, the immigrant visa should definitely already be available. So a few things that you can do actually, Lackey X Winden. So a few things that you can do is, first of all, you can reach out to the NVC by submitting the public inquiry form, and I'll show you how to do that. So you can find this link for the visa bulletin. I'm sure you're familiar with the visa bulletin. You can find this link in the description below. Just click on this. When you click on it, at the very top you will see contact us. So we're gonna go here, and then we're gonna go to US visa contacts right here on the left side. And then we'll scroll down a little bit and you will see this table at the very top column. You will see at the very top right here, there is email, public inquiry form. So we're going to click on this, and then you will see once again, right here, it says online immigrant visa inquiries only, public inquiry form. We're going to click on this, and this will give you the public inquiry form. So you will put your case number here. Principal applicant is going to be the beneficiary. Date of birth, principal applicants is going to be beneficiary's date of birth. Petitioner's full name right here. Who are you, petitioner or beneficiary? Your email address. And then in your inquiry, you will say, hey, you know, I'm already documentarily qualified. I'm waiting for my interview. Judging by the visa bulletin, by June 2023 visa bulletin, my immigrant visa should already be available. And I'm not scheduled to interview yet, so I just wanted to follow up and see what's going on. You can also reach out to the US Embassy and ask them. They might give you the information. They might provide you information. They might not. Don't be too upset if they don't. And actually, you know what? I'm going to double check myself because it is September. So September 2015. So they are already processing September 2015. So they already passed June. Yeah, so they are already over, let's see, June. So it's the end of June. So let's say July, August. So roughly 2 months over. The other thing, because I really don't want to, you know, scare you or anything like this. There might have been some kind of delay, for example, in documentary qualification process. Let's say if there was, you know, you submitted the document and they took a couple months to review it, and then they said, no, we need a different document, or we need a translation for this document, or something like this. And then you submitted an updated document, and then a couple months later, they responded and said, okay, we have received everything needed, good to go. In that case, you know, that could have created a little bit of delay as well. Keep that in mind. But still, you know, you're there, judging by the, you know, visa bulletin. So you can definitely submit the public inquiry. You can definitely reach out to the US Embassy and just see what's going on for an update. But it should definitely be somewhere around the corner. Alrighty, let me put this and we're gonna move on to the comment from, let me put this before I forget, from Farida Kathawala. Says, thanks so much. You're very welcome, Farida. I hope my answer was helpful. Let's do another one. From Mira Ragbir. Oh, thank you, by the way, for being public. Subscribe, Mira. Appreciate it. also says, thank you so much. You're very welcome. Moving further to Butter is Good. Thank you for answering all our questions. You're very welcome. Thank you for watching. I have a question on I-120B. I'm sorry, I-290B. I've been talking for way too long. If I am the petitioner on I-485 for my wife and Form I-485 was denied by National Benefit Center, should I, the petitioner, put my information on I-290B or my wife, who is the applicant, on I-290B to reopen the case? I appreciate your answer on this matter. Okay, so it's excellent question. I haven't had a question like this before. So, you're the petitioner for your wife on I-130, and based on that I-130, you are filing the I-485 for the adjustment of status, the application for permanent residence. So, I-485 is based off the I-130. Now, if they have rejected, if they denied the I-130, then you would have been on the I-290B. But because it is I-485 for your wife applying for permanent residence, the adjustment of status, then it is her. And because they denied I-485, then it is her that has to be on the I-290B. But excellent question. And also, I think I've mentioned that in my previous response, because I remember it was related to the 290B. I would say it again. I would repeat it just so that everyone knows that whenever it comes to filing, the appeals and stuff like this, make sure that you read the denial letter carefully, because a lot of times they give you a much better option than filing the appeal, because it might be just as easy as sending a letter saying, oh, you denied my application based on this. Here is the additional information that you needed. Please reopen my case, or please reconsider my case. And it's much easier, obviously, for them to just look at it. Oh, okay, so he submitted the evidence. We are reopening the case. Now we have the additional evidence that was needed. Let's reopen it. And instead of completely doing the appeal, because it starts the whole new process of the appeal. And I also have one email that I have received. I'm going to open it right here in a window on my other screen. It is email from Chahid M. Mowad. Sorry if I'm mispronouncing the name, but I'm going to read it and I'm going to try to answer it. And also, I'm going to encourage everyone, if you want me to get to your comments, questions in time, please submit them as a comment on this channel and not through the email, because literally for some reason every email that I've addressed on this channel have been going to my spam folder for whatever reason. I tried to fix it, but it still keeps coming to the spam folder. So I'm going to read it. First, I would like to thank you for all the videos, info and help you're providing to everyone. If you can help me with some details if possible, I'm a US citizen and filed for my wife and son, which currently they are residing in Lebanon. I filed Form I-130 for them, and USCIS receipt date was July 2022. Okay, so the priority date is in July 2022. I'm checking the online portal, and in April it changed, and it seems like it was delayed by an additional 4 months to get a response on the first phase. From your experience with all the people you're getting info from, when do you think I should be expecting a response on the USCIS phase? Your reply is much appreciated. Best regards, Chahid Mowad. Chahid, sorry that you're dealing with this. I know this is frustrating, and I actually did get quite a few comments from people saying that they have been watching the processing times closely on USCIS website, and at once, and it happened like it has been happening for the past couple months, that these processing times, they have been growing and becoming longer. It's definitely frustrating, but at the same time, it's better to see stuff move, and I always say that, than looking at it and it's not moving, and then you're realizing that you're already past the normal processing times and nothing is happening, and you don't know what's going on, if the numbers are updated or not. So we rather see them move in not such a positive way and know that, okay, these numbers are now updated, so I know roughly that now that you roughly have to wait another 4 months from what you've been thinking, rather than reaching that date and then not knowing what's going on. So the best thing to do, I mean, it's saying, be patient, of course, is annoying, but I can personally relate because I myself have a petition that I'm waiting on, that I will be waiting for a very, very long time on. So I know how it feels to wait and be patient. All right, even though I'm not not really a very much patient person. But the best things to do is keep checking, stay on top of it. Once it reaches that date, the new date that is showing now, and if nothing is happening, as soon as it reaches that date, submit the case inquiry with USCIS, because I'm talking about public inquiry form for the NVC, and then really with anything throughout the whole process. Once your USCIS case is approved, once you're transferred to the NVC, if you're suspecting that it's taking longer than it should be, stay on top of it and reach out to them. Be polite, be professional. You don't want to, start any kind of unnecessary drama within your case, because you can. I've seen that happen. I've seen if you're not polite, if you're, it's not very good. You do want to be polite every time, but at the same time, you want to stay on top of your case. And if you're suspecting that something is taking longer than it should, reach out. You reach out to USCIS, you reach out to the NVC. If you don't get a decent response from them, then you start looking for other avenues. But as of right now, there's really not much you can do. I would say, find the positive within it, because now you know the updated times. Instead of waiting extra 4 months and thinking that your case is outside of the processing times and not knowing what's going on, you now know that there was some kind of delay in the processing, and you will be waiting extra 4 months. It's annoying, but it is updated information, and it's much better than being completely in the dark. So thank you very much, everyone, for your questions. Thank you very much for tuning in to this video. As always, I appreciate your time. God bless, and I'll see you in the next video.